At kagunay pa rin ang first appearance si dating Pangulong Duterte sa ICC, makakausap po natin ng legal expert at direktor ng Reparative Justice Program ng International Center for Transitional Justice, si Attorney Ruben Carranza. Sir, magandang hapon.
Good morning po sa inyo dyan, sir.
Wait,
At
what's your name?
magandang gabi.
Miles Malaya.
Magandang hapon, Ed.
Hello from
Hello,
my
our friends.
Sorry, sir, may pumapasok na
You're
audio.
also lawyers?
Yeah, but I'm not
Sir, ayan, wala na. Okay, sorry, sir.
We're good na,
May
sir.
party line.
All right. Hello, thank you for joining us, sir. We appreciate your time and effort for being on the show.
Thanks for having me.
You go first, I go first.
Okay. Sige, sir.
Sige.
So, unang-una, magandang gabi po from the Philippines. So, yun nga po kanina natanong namin, what's the pre-trial chamber going to look for para mag-forward yung trial sa kaso ni former President Rodrigo Duterte? You know, we've been hearing terms like quantum of evidence needed. For example, the idea of interim liberty. Does that apply for this case?
Yeah, so, as the name of the chamber and the activity suggests, it's a pre-trial chamber. They're in charge of all pre-trial matters. In other words, before the trial begins. And the most important thing that they're in charge of as far as moving this case forward is what is called the confirmation of charges,
But
which
sir, that
will be scheduled, which has been scheduled for September 23, so a couple of months from now. So I think it's important to distinguish between what everyone watching just saw a while ago. It was not the confirmation of charges hearing.
sir.
It was just meant to inform Rodrigo Duterte of the charges against him, not to confirm those charges, which will be the hearing in September. Now, the confirmation of charges hearing is important because it's not just an exercise in reading the charges, which was already done today, but it's also a step in which the prosecutor, and your viewers saw the ICC prosecutor Karim Khan and his team, the prosecutor will be asked to essentially identify what evidence they have to support the charges, whether they have other evidence that they are going to provide, and whether they intend to amend the charges, whether they intend to change some charges, drop some others. That's an important consideration because if you remember, the warrant of arrest talks about 3 crimes: the crime against humanity of murder, the crime against humanity of rape, the crime against humanity of torture. But the judges who you just saw from the pretrial chamber, they were the ones who issued the warrant, removed torture and rape as basis for the warrant of arrest and specified only the crime against humanity of murder. It's possible that those charges will also be dropped, but it's also possible that those charges will be retained. So we'll find out between now and September 23. The last point for now that I will say is for everyone watching to take note that the presiding judge also said that in response to the so-called manifestation of Duterte's lawyer, that all the things he said can be raised before the confirmation of charges hearing. So before September 23, he can raise those things, including, as the presiding judge said, issues of jurisdiction. That is a very important statement.
Well, sir, if I'm getting this right, yung kanina was basically procedural pa lamang. The more substantive issues would occur around the time of September this year for the confirmation of the charges. Am I right, sir? So, yung today talaga was basically logistical administrative more than anything.
Correct. I mean, that's the reason why they needed to ask him what his name is. When he was born, just to make sure that he's the same person being arrested. Remember, the reason I'm not calling him a respondent is because until the charges are confirmed, he is just a person arrested who may be charged. Ed, what is important is not only the hearing on September 23, but what happens between now and September 23. That's why I mentioned jurisdiction, because between now and September 23, the Rodrigo Duterte can actually challenge the jurisdiction of the ICC in this case.
How, sir? Will there could he make the filings even outside of the actual hearings, and would they be decided on before the 23rd, or will we have to wait for 6 months before any petition or
So
motion?
those are three questions. He can file a motion for the court to dismiss,
Yes, sir.
or for the prosecutor to withdraw the charges, depending on how they articulate their challenge to the jurisdiction of the court. They need to file an actual motion.
Yes,
They
sir.
can't just raise it at the hearing on September 23. Your second question, who decides it? When do we know? The pretrial chamber can decide it. And there might even be a separate hearing between now and September 23, possibly, or
Okay.
most likely after September 23, on this question of jurisdiction. But in any event, this question of jurisdiction, if Rodrigo Duterte raises it, will likely take precedence over the confirmation of charges.
All right. Sir, as we were speaking to our correspondent in The Hague, we have Gretchen Ho there. We talked about the interim release. Is that the same with posting bail? Because I think under the Rome Statute, Article 60, former President Duterte can actually post bail for provisional liberty.
No, he can apply. He has the right to apply for.
If the judges determine that there isn't a risk of flight, obstruction, or crimes don't continue. So is he entitled to this, or does it largely depend as well on the nature of the cases filed against him?
He's entitled to ask for temporary interim release while the proceedings are pending. What's important to remember, two things. He can ask for this at any time. Not only now, but even later. But the
being
second point
granted is a
to
different
remember, the pretrial chamber actually had two options in bringing Duterte to the ICC, to the court in The Hague. One was the warrant of arrest, which is what they issued, but the other option could have been a summons, meaning, come over to the court, we want to hear you, we want to tell you that there are charges that are going to be filed against you. A summons is lesser than a warrant of
Yes,
arrest.
sir.
You cannot be compelled to obey a summons. A warrant of arrest, as you saw, is compulsory. You
Yes,
will
sir.
be arrested and taken to the court. There was a reason why the ICC pretrial chamber opted for a warrant of arrest instead of a summons. In a previous case, for example, against, at that time, the incoming president of Kenya, Uhuru Kenyatta, and his vice president as well, they were charged with crimes against humanity. Instead of a warrant of arrest, the ICC issued a summons to both of them, and they did appear at the ICC. They did not have to file a motion for interim release because they were only summoned, they were not arrested. On the other hand, another example, the former president of the Ivory Coast in West Africa, Laurent Gbagbo, was arrested, brought to court. He asked for interim release. He was not granted interim release. So the court weighs not just the idea of whether this person might evade, but also whether this person might influence or even intimidate witnesses,
In the
other
case.
potential people who will be part of the case, and considers that in determining interim release.
Sir, my last question, sir, very quickly. Listening to Attorney Medialdea talking kanina before the pretrial chamber, he said, and I'm paraphrasing here, two troubled entities struck a deal, the incumbent president and the troubled legal institution, again paraphrased, in need of a legal show today. Of course, I don't think he named any names, but I suppose he was referring for the second part to the ICC. Kumbaga, pinhapiawan niya yung ICC. I'm wondering lang what effect this could possibly have on the ICC, which in the end is the one that's also trying the case.
Well, maybe three things, Ed, no, to respond. It's important to note most ICC cases, especially those involving heads of state or high government officials, are always political, both in the country where those officials are from and as well as in the ICC itself. So it's unavoidable. At the same time, there has been an effort by the prosecutor, not just the current one, but previous ones, to avoid politicizing prosecution, although the success in which they've done that varies. But the second point that I think is also important for Filipinos watching, Salvador Medialdea was Duterte's lawyer just for this hearing. I'm not sure that he will be Duterte's lawyer for confirmation of charges and other motions they want to file. He, in a way, I can say he knows what he's talking about, political score settling. This is just a fight between two families. Why? Because aside from representing Rodrigo Duterte today for crimes against humanity for murder at the ICC, Medialdea, through his law office, represented Ferdinand Marcos and his family in the tax evasion case arising from the plunder they committed. He has represented both families, and that's, in a way, the tragedy of all of this. These two families fighting over murder and plunder. There are no references whatsoever to the victims of the drug war. There are no references to the victims more generally of all the plunder and the murder committed in this history that involves both families. And so the ICC as an institution will avoid that. There was no response from the chamber because they are not involved in any of that. They will try the case as best as they can.
Okay. Okay, maraming salamat, sir. Attorney Ruben Carranza ng International Center for Transitional Justice. Sir, thank you for joining us tonight. Mga kapatid, Ed Lingaw po, maging maalam at may pakialam sa mga napapanahong balita sa ating bansa. Para sa mas malalimang pagtalakay at paghimay sa mga issue at headlines, tumutok lamang at mag-subscribe sa social media pages ng News 5.